Hello, and welcome to our show, Crooked Doctors. We're a live call-in show. Today is Friday, July 15th, 2011, and you can give us a call at 212-245-2473. That's 212-245-7273. So, this is our live call-in show. This is show number 4. Thank you for tuning in. July 15th, 2011, 212-245-7273. Here's what I did this week that I thought would be helpful. For each show, I'm presenting evidence that shows a police detective lied about me. The Manhattan District Attorney's Office lied. In addition to these narratives, I decided to post the documentary evidence on a blog. So if you go to your search engine and you type in between quotes, http:// and as one word, crookedDoctors, .blogspot.com, you will see some notes and the documentary evidence that supports the narrative that I'm giving you today. You can also email us at crookeddoctors@yahoo.com, and if you have questions, if you miss our call-in, you have questions, I will respond to them. And you can look at our videos on YouTube, and I'm going to start putting these tapes of these shows up on YouTube videos and linking them to other websites so people can see them. So you can go to YouTube. There's one video that was unfortunately taken down. I think I have to go back and check, and that's this video right here that we started handing out to folks. And I'm going to post this again, and there's a reason for this I'll show you in a minute. So thank you for tuning into our show today. And if you're watching at home, that's really great. If you can't get to your TV, you can watch us streaming live on the internet. And this is Manhattan Neighborhood Network. This is where I broadcast all the helpful people. Thank you, Malik! I promised Malik I would say thank you. But this is Manhattan Neighborhood Network. This is where we broadcast from at Columbus Circle, and you can click on Watch MNN Live, MNN1 channel live, and you hit play, and you'll watch us streaming live on the internet. So that's terrific. And today's show, I'm going to show you how well, let me do an overview of what we've learned so far. Show 1 was sort of broad brushstrokes about how I've been persecuted by my medical school for almost 20 years. And these psychopaths, there's no polite way to say this, these psychopaths engineered a physical assault on me that left me with serious bodily injury, could have left me paralyzed or dead. I got a little criticism last week that, you know, I should wear makeup and get my hair done, and I'm always wearing the same clothes. You people ain't getting this, okay? Assistant District Attorney Alex Spiro threatened me. He acted on his threats. His trial supervisor, that would be Michelle Bayer, threatened me. She acted on her threats. I have a police detective on the record who lied about me, and thank goodness at trial, on the trial transcript, admitted that he lied about me. So the district attorney's office has presented perjured testimony. Now, Mr. Vance is quoted in the news media as saying his office, District Attorney Vance, Cyrus R. Vance Jr., quote, "Our office's commitment is to the truth and the facts," end quote. So, Mr. Vance, let's stick to the truth and let's get to the facts. Now, last week, I had a guest on Crooked Doctors, crooked lawyers, crooked judges, crooked police. I got a sewer here I'm dealing with. We had a guest, Gilbert James, a very nice gentleman, who got his master's degree from Yeshiva University's School of Social Work. And during the interview process, they told him, look, this is a religious school. If you come here, you're going to be required to take religious classes. So what I have here in front of me is something called evidence, Mr. Vance, because I'm taking these I tape live, and I'm going to take these tapes and put them up on YouTube. YouTube does have, will confine me to 15 minutes, but I can, take these hour-long programs and put them into 4 parts so that my attorneys for the appeal will be cutting and pasting from the information that I'm posting on the internet. So this is called evidence. And I'm going to get to this in just a minute. You want to know what this is called? This is called evidence. These are photographs that I took this week on the Q train, on the subway, and at City Hall that show there is a state agency involved in federal student loans. My issue in contacting my medical school was that my medical school had falsified financial records. These people at Yeshiva University's Einstein School of Medicine falsified my educational records. My transcript is a joke, for example. They falsified my educational records. They falsified my medical records. They falsified financial records. So my purpose in contacting my school was to correct intentionally falsified financial information. And by the way, I had a meeting with Cheryl Fisher, the supervising attorney at the Higher Education Services Corporation. That's the state agency whose job it is to oversee what goes on at schools. So what happened to me and other innocent student victims wasn't supposed to happen. And I paid the Higher Education Services Corporation, the state agency involved, a fee. Between 1% to 3% of my student loans went to the Higher Education Services Corporation, the state agency located in Albany, whose job it is to make sure that when my school made promises to me and were supposed to provide other services, they did. They didn't. And right now, the Higher Education Services Corporation is advertising on the subway. I'm going to develop these pictures, Mr. Vance, and post them so you can see them. But you should be able to see them because one of these posters from the Higher Education Services Corporation is at City Hall Station. It's hard to miss. City Hall Station, where Mr. Vance might actually pick up the train and see the poster from the state agency involved. Judge McLaughlin, Edward J. McLaughlin, lied. He deliberately created a false record. He claimed there was no state agency involved. There is a state agency involved. Here are photographs that show that. I had to go to Congressman Joseph Crowley and ask for a letter of introduction to the Higher Education Services Corporation. So Congressman Joseph Crowley is my witness in the upcoming 440 hearing, where he will authenticate his letter introducing me to the Higher Education Services Corporation, where I went with other student victims and a community leader named Alan Raskoff. We traveled to Albany in 2006 and had a sit down with supervising attorney Cheryl Fisher, who has done nothing except, well, we'll get to that later. But the bottom line is the purpose of the farce of my criminal trial was to create a false record. And the reason why Martin Bockstein at Yeshiva University is so obsessed with making sure that there's no state agency involved is because what he doesn't want, and one would know this had one studied the Garg case, what he's desperately afraid of is a 42 USC 1983 claim. And in order to make that claim for civil rights violations, there would have to be a state agency or a state actor involved. There is the Higher Education Services Corporation. And one of the things that I was talking to with other student victims was they had the ability, and this is a really good creative idea on my part, you can use your student loans, the statutes that govern the administration of federal student loans. You can use them to offer to get a level of protection. As medical school students, we have very little protection, as my case clearly demonstrates. But the union, the employees have the unions behind them. The professors have obviously more resources than the student, they're professors, but they also have a faculty handbook. That's the stated policies that offer them some protection. But as medical school students, we're easy prey. And if you use your federal student loans, if you read the statutes in federal student loans, you can get some protection, as I'm demonstrating. So this is evidence, Mr. Vance. I'm going to develop these pictures and send them off to you. Judge Edward J. McLaughlin, the judge in my case, who claimed there was no state agency, probably catches the train from City Hall and might actually see the poster with the state agency on it. And there's all kinds of other evidence I have that shows there is a state agency involved, and Judge McLaughlin lied. This is evidence. These are CDs that I made, and we distributed these widely. And the importance of these CDs that say, "Please stop the railroading of Lidya Radin," we handed these out like candy. The importance of this is because I made this on or about April 3rd and published it on YouTube on or about April 5th, 2010, last year. I didn't go to trial till 2 or 3 weeks later. And what I'm talking about here is how I had gone to the Manhattan District Attorney's Office in 2008 with Mike Tyberg, another student victim of federal student loan fraud. So my complaints against Yeshiva University came first. They were for fraud, not for aggravated harassment. And as I'm going to show in this show, Detective Cologne lied on the witness stand, admitted that he lied on the witness stand. So, just to review, show 1 was broad brushstrokes. You want nothing to do with Yeshiva University if you're out there. Show 2, I got into a little bit of detail about how Assistant General Counsel John Scarfone at Yeshiva University went into federal court in 2006. I was named as a witness against him and the other complaining witnesses in my case. So in 2006, I was named as a witness against my medical school. The school paid lawyers to go into court and lie, and one of the examples that I showed was that John Scarfone, Associate General Counsel at Yeshiva University, went into court, federal court in 2006 and claimed that I, as a first-year student, failed all my classes except for Todd Olson's anatomy class, you know, because Todd Olson is such a nice guy. Todd Olson's not a nice guy. He's a pervert. He's profoundly disturbed. You need to stay away from this guy. In 2009, my school released documents in response to a subpoena. Do you believe that I actually had to get a subpoena? The school release documents, the Manhattan District Attorney's Office had in its hands for at least a year before trial irrefutable documentary evidence that was released by my school that showed John Scarfone, a complaining witness against me, was a liar. And I went through some of those details. Now, on my blog site, which I'm going to pull up for just 1 second. Oh, here's my blog site. Let's go look at that. Okay, so this is the Crooked Doctors blog site, and you can go to http://crookeddoctors, one word, .blogspot.com, and you're going to find the evidence that I'm posting. So I'm going to scroll down. Let me orange this a little bit. I'm going to scroll down. Here, this is the evidence for, there is no polite way to say this, let me go down a little bit. This is the evidence that shows for, evidence in shows 1 and 2 that John Scarfone is a liar. And very briefly, I'm just going to scroll through this. This is a brief synopsis. My complaints came first. John Scarfone lied about me. I made my complaints against Yeshiva University in 2005. 2005, in 2006, John Scarfone lied about me in federal court. In 2009, my medical school released documents that showed John Scarfone lied about me in federal court. He had a retaliatory motive. And right here, posted for you. We went through this in detail during the first show, but right here, John Scarfone says, very quickly, let me just punch this up for you, that I failed all. In fact, Todd Olson's anatomy class is the only class Miss Radin passed during her first year of medical school. That's a lie. And following that are performance evaluations from a class I took called Introduction to Clinical Medicine. And these documents are posted here that show that I did not fail all my classes as a first-year student except for Todd Olson's anatomy class. And at criminal trial, Dr. Blau stipulated to that. I was one of her professors during first year medical school. She did not fail my class. Why is that stipulation important and targeted? Because Dr. Blau reported my passing grades to a guy named James David and to Janice Bennett. They were directors of the ICM class, the Introduction to Medicine class. So when Dr. Blau passed me in the class and reported my passing grades, he reported it to two entities. One, he reported it to my promotions committee, where all the complaining witnesses in the farce of my criminal trial sat. So Dr. Blau reported my passing grades to my promotions committee, and he also reported my passing grades to James David and Janice Bennett, who were directors of the ICM class. Now, Jimmy David is a complaining witness against me. He's a liar, and he knows that I passed the class, and he knows that 3 years before he filed false criminal charges against me. He knew that John Scarfone had gone into federal court in 2006 and lied. Ooh, you know, I go high-tech, but I also go low-tech, because the purpose of this show is to effectively communicate information. So it's not a matter of, bells and whistles and being sophisticated and showing off, all your skills. The point of this is that you get the information, whether I go high-tech or low-tech. And I got a little criticism last week. You should wear makeup, you're always in the same clothes, you should have your hair done. I have a police detective who lied on the witness stand and admitted to doing that. A police detective lied to illegally incarcerate me. I have assistant district attorneys who lied. And in this show, I'm going to show you how Linda Tacoma, assistant district attorney at the Bronx District Attorney's Office, lied in 2005. So now we're going to go low tech for a minute, and we're going to look at the timeline, because it's not rocket science, folks. In 2005, Judge Patterson in May ruled against me wrongly. In 2005, about a month later in June, I discovered falsified financial information that gave me newly discovered evidence, which gives me the ability to amend my federal complaint under a 60B4 motion, and it's a relief from final judgment, not a motion for reconsideration. In 2005, I organized up the evidence and with other student victims through Congressman Weiner's office, sent all this information to the Bronx District Attorney's Office. In October of 2005, Assistant District Attorney Linda Tacoma wrote back to Congressman Weiner's office, and she lied. And I'll show you the very simple example that showed she lied. In 2006, John Scarfone went into federal court and lied about me. I was named as a witness in another student's case. And I said, use my name. I'm not afraid of these people. Use my name. So in 2006, another student had named me as a witness against John Scarfone, Jimmy David, Dan Rozelle, and Todd Olson. And I stood up against them. And what I got for being named as a witness was 3 years later, they filed false criminal charges against me. There's a lot of events that happened through here, namely in 2008, me and Mike Tyberg went to the Manhattan District Attorney's office and showed them how the school lied to steal money. So the Manhattan District Attorney's office could have done something 2 years before I was illegally, before the farce of my criminal trial. In 2009, false criminal charges were filed against me. And the purpose of those false criminal charges was to get me to sign a contract wherein I would agree never to see my records from Yeshiva University. Of course, John Scarfone and Martin Bockstein and Dan Rozelle, the dishonest attorneys who are paid by this dishonest school, want me to sign a contract wherein I would agree never to see my records from Yeshiva University, so John Scarfone could get away with lying about me in 2006. So in 2006, John Scarfone goes into federal court and lies about me. And then in 2009, after I had already been to the Manhattan District Attorney's office, in 2009, these dishonest attorneys and other school officials file false criminal charges against me, and the Manhattan District Attorney's office, this is Robert Morgenthal's office, negotiates for the school. Robert Morgenthal's district attorney's office negotiated for the school, and what they wanted, do you love this? Since when does the Manhattan District Attorney's office negotiate for a private university filing thousands? They filed 11,198 false charges against me. 11,198 charges. I was like, you know something, Assistant District Attorney Alex Spiro? In order for you to make your case, each one of those charges, each one of those so-called crimes has at least 7 elements. So you're going to have to sit down and write 7,000 elements in a prosecutor's information times 11,198. And that'll be what, 77,000 points of information you're going to have to give to me? Good luck, Alex Spiro. You'll be writing a book for 5 years. That's what we're paying you for. So the purpose of filing thousands of false charges against me was to intimidate me, scare me, bully me into signing a contract to get John Scarfone off the hook and to get Martin Bockstein off the hook. Because Martin Bockstein, dishonest attorney paid by Yeshiva University, thinks that he can undo law by contract. He can't. You can make law by contract, yes, but you cannot undo law by contract. Because that violates public policy. You cannot create unconscionable contracts and bully people like me into signing them. So the bottom line is, I want to jump into how Linda Tacoma lied and how, because we're halfway into my show now, and I really want to get into the evidence here. So what I'm going to do is go straight to some of the evidence right now. And what I'm going to look at is, actually, I'm going to segue for just a second. These books that I have right here, these are medical school admissions requirements. And last week we had Gilbert James on the show. He was a gentleman in Washington Heights who got his master's degree from Yeshiva University School of Social Work. And during his interview, he was told that Yeshiva University was a religious school and that he would be required to take religious Jewish classes. In these books here, these are medical school admissions requirements from 1994. These are medical school admissions requirements from 1996 to 1997. The authority here is the Association of American Medical Colleges, and the medical schools report to the Association of American Medical Colleges. So you've got Yeshiva University, which is the umbrella, the mother university, which is a religious school, and they were found in 1999 to discriminate on the basis of religion in the Diane Persky case. Diane Persky, recall, is a conservative Jewish woman who was told she wasn't Jewish enough, so they ruined her career. In my case, Yeshiva University stipulated to discriminating against me, and we'll get into those details. But the school, when I was applying, this is what they stated. This is the authority. the Albert Einstein College of Medicine, and I'm going to post this so you can confirm it for yourself. The Albert Einstein College of Medicine is a privately endowed, coeducational, and non-denominational institution. They lied. They're a religious school. They're not non-denominational. This is in 1994 to 1995. Diane Persky was laughing when I was reading this to her. She's like, Lydia, everybody in the New York Jewish community knows that Yeshiva University is not non-denominational. They're an overtly Orthodox Jewish school. They're closed on the Sabbath. There are religious rules imposed on the students who go there. And the Asian students feel just as deceived as I did, because they can't even have their traditional dishes, which include pork. Oh my God, you can't possibly have a meeting in the school cafeteria if you're an Asian student, as part of the Asian Students Club, and serve your traditional meals, because you have to obey Jewish religious, Orthodox Jewish dietary practices, which say you can't. You have to have kosher meals. These people are such a pack of liars. Medical school admissions requirements. This is from 1996 to 1997. The Albert Einstein College of Medicine is a privately endowed, coeducational, and non-denominational institution. No, they're not. They're a religious school. And the part I really love, this is great, financial aid. Every attempt is made to assist students and their families in meeting their financial obligations to the college and the students' essential personal needs. What a pack of liars these people are. When I was a student at the school, I asked for access to federal work-study money. They refused to allow me access to federal work-study money. And here's the lie they told. Oh, we're not discriminating against you, Ms. Radin. We just ran out of money. That's not true. That's a violation of the law. That's not how federal work-study money is administered or distributed. What happens is all students who are interested in applying for the federal work-study grants are supposed to submit an application, and then the available monies are split up equally among all of them. But the bottom line is, at a major university like Yeshiva University, there's no shortage of funds when I was a student there to access federal student loan money. That's just a lie. At Columbia University, you would, for example, apply. They would award you $4,000 for a semester. There's no way you would earn $4,000 a semester, but if you wanted to, you could go back and get another grant for $8,000. You could potentially earn $8,000 while you were a student, which is, not bad if you're a student, but you'd never be able to work all those hours, so it's just nonsense. Yeshiva University lied. And by the way, in order for you to get federal student loan, federal work-study money, you have to fill out an application. You have to fill out time sheets every 2 weeks. There has to be some supervision. These people are just a pack of liars. There was plenty of federal work-study money for me to access if I needed to, and for me to help fund my research project when I was working at Long Island Jewish Medical Center. These people are liars. They're not non-denominational, they're not non-sectarian. This is an overtly Jewish school. Who cares? All the school had to do was be honest, but here's the problem. Yeshiva University wants to sit on 2 seats. What it wants is lots of public money to promote private religious education, and in order to do that, it has to lie and pretend that it's non-denominational and non-sectarian. Yeshiva University could have made a decision to go wholly private, and then they could do whatever they want. They could have all their religious rules, discriminate. As long as it's not on public money, they could. They don't. They want it both ways. And actually, as I was saying to my parish priest, who's again, I used a little humor when I went down to talk to my Senator Schumer, about this. And when I used a little humor, I said to Senator Schumer, who's against? I think it's fabulous. We all pay taxes, and our tax dollars go to promote private religious education. So how much money, Senator Schumer, do the Catholic schools get? And when I ask that question, what I get is a phony baloney separation of church and state argument thrown in my face. So the big picture is we all pay taxes, and a small segment of the population, Torah College, Yeshiva University, get a great benefit. They get to promote private religious education at public expense. And when the rest of us ask for the same fair shake, the same equal break, the same equitable funding of our religious schools, what we get is a phony, baloney, separation of church and state argument thrown in our faces. And if you go to YouTube, you'll see me address Mr. Vance, the new district attorney, at his first town hall meeting in Washington Heights last year when he was a new district attorney. And I say to him, can you show me, Mr. Vance, the great big wall of separation of church and state at Yeshiva University, because I don't see it. Show it to me. And that's important because we're going to get into Mr. Mikey Weinstein and Military Religious Freedom Foundation. Mr. Weinstein is busy building a great big wall of separation of church and state in the military. And my question to him was, well, Mr. Weinstein, you've been to Yeshiva University, you asked them for money, they told you you weren't Jewish enough, they insulted your wife by saying she wasn't Jewish enough. Can you show me the great big wall of separation of church and state at Yeshiva University and Torah College? Because I don't see them. And he can't show them to me. And the reason why Yeshiva University did not want to give money to Mr. Weinstein was not only because he wasn't Jewish enough, and Mr. Weinstein said to me almost word for word, Lydia, these people are bigots. Stop dancing around it. Just say it. They're racists. I'm Jewish, and I'm not Jewish enough for them. My wife is Jewish, and she's not Jewish enough for them. But the real reason they didn't want to give you any money, Mr. Weinstein, was because they were afraid that you would attract attention, because as you're busy building the great big wall of separation of church and state in the military, there is no great big wall of separation of church and state for Yeshiva University and Torah College, and they didn't want to attract attention. So that's another reason why Yeshiva University refused to fund your Military Religious Freedom Foundation, sir. So what we're going to do, because we have about half an hour left and I want to get into this, is I'm going to post on the blog site pages 30 to 41 of Detective Cologne's testimony in my criminal case. And the important part about all this is that Detective Cologne lied. He has no credibility. If you're out there in the viewing audience and it's your word against Detective Cologne's word, you win and Detective Cologne loses because Detective Cologne lied. And again, this is not fun and games for me. I have a police detective who admitted that he lied to put me in jail. And I've got 2 assistant district attorneys and Mr. Vance's office who threatened me and acted on their threats. So I'm going to give you the brief synopsis. This is posted on the blog site, or as soon as I turn these pages, this is pages 30 to 43, into JPEG files. I'm going to post them and you can read this for yourself. It's incredibly easy. It's not very time consuming at all, but I'm going to give you the synopsis. And the synopsis is that my complaints came first. My complaints against Yeshiva University were for fraud, not for aggravated harassment. I had no retaliatory motive, and the reason no one wanted to do anything, Detective Cologne, was because for federal student loan fraud, Yeshiva University will lose its ability to administer these programs forever. There is no way for the school to regain eligibility because the federal government feels that it's been very generous with schools in guaranteeing student loans and backing student loans. The federal government has been subjected to every scam in the world, and they've had it. So they laid down the law. So I'm going to read you very quickly some quotes, and then I'm going to show you, I'm going to segue away to showing you how the Bronx District Attorney's Office in 2005 lied to Congressman Weiner's office. And I'm going to give you an overview very quickly. And let's bring out the low-tech poster board for a second before I go high-tech again. But in 2005, Judge Patterson in federal court ruled against me. And it was the wrong ruling. I'll show you an example in this show. In 2005, in June, a month later, I discovered a falsified promissory note. And in 2005, I organized up all the evidence with other student victims of Yeshiva University. We went to Congressman Weiner's office. Through Congressman Weiner's office, we sent everything to the Bronx District Attorney's Office. And in October, Linda Tacoma at the Bronx District Attorney's Office wrote back, and she lied. I'm going to show you how she lied. After that, I went to the Jersey City Police Department in December of 2005, got a police report, showed everything to Sergeant James Sullivan. He's known as Scully to his friends. Sergeant Scully, hi! Sergeant James Sullivan looked up some statutes and photocopied them for me. He'll remember this because I checked at least 2 or 3 times since then with him. He's like, yeah, I remember you. Yeah, that's something I would have done. I would have photocopied the statutes for you. You have consumer fraud, Miss Radin. And for consumer fraud, you get attorney's fees in addition to your damages. So try not to get too upset. And he made phone calls. Those phone calls can be traced. He called his detectives and he called the Bronx District Attorney. So we're going to fast forward to 2010, and here's how Detective Cologne lied at trial to cover up for Yeshiva Universities to participate in Yeshiva University's ongoing crimes against me. On page 37, Detective Cologne claimed, quote, a case involving her aggravated harassment against the university. And he says that he felt that I was filing the complaint to get back at the university for having me arrested for aggravated harassment. The school claimed it was annoyed because I asked to access and correct my records because my records have been falsified. So on page 37, Detective Cologne says that I have a case of aggravated harassment against the university. That's not true. I saw Detective Cologne's report when it went down to the Manhattan District Attorney's Office, and Detective Cologne named me as a victim in federal student loan fraud in 2009. And a year later at trial in 2010, Detective Cologne got turned. I don't have a case involving aggravated harassment against the university. My case was for federal student loan fraud. He felt that I was filing this complaint to get back at the university for having me arrested for aggravated harassment. My complaints came first. The school filed complaints against me. Here we go, low tech again. The school filed complaints against me in 2009. I was reporting federal student loan fraud in 2005, 4 years before. So I had no retaliatory motive. My complaints came first. And Detective Cologne says, sometimes we see that. We see that somebody gets arrested and then they file a complaint against the other person, okay? That's not true. These statements were made by Detective Cologne in an effort to confuse my case with another student's case, and I'll get into those details. On page 39, I protest and I say, you know, we're not quite done because I reported this in 2005. And Judge McLaughlin says, it doesn't matter a whit. Yes, it does matter. And the reason why it matters is because it opens the door to the events of 2005 and to Linda Tacoma, how she lied, and about, well, I'll show you in just a second. It opens the door to Linda Tacoma lying in 2005, and that opens the door to Judge Patterson in the federal courts. And it shows that Judge Patterson lied. So what we're going to do now is go a little high tech, and we're going to go to, this is how Linda Tacoma lied. And I'm going to enlarge this document. And you should be aware that the U.S. Marshals have this document. In fact, I'm pretty sure that Judge Patterson was pretty embarrassed. Now, what I want you to do is get the big picture here. Okay, so this is called timeliness of actions. You don't have to see it right now, but I want you to get the overall gestalt. Okay. I want you to get the overall gestalt, and what Linda Tacoma did was she'll show. She's going to. How do I show this? This is a standard propaganda technique that I'm dealing with, and what will happen is when presented with a document, Linda Tacoma will, or you know, the dishonest attorneys that I'm dealing with, they'll point to the first paragraph, but they won't give full, true, and complete information. So they'll quote paragraph 1 and say, oh, you know, we've proven something. But yeah, but if you read down to paragraph 2 and paragraph 3, you'll see that you really, you lied. You gave incomplete information. So I'm going to show you the overall gestalt first. When you look at timeliness of actions, okay, this is what Linda Tacoma quoted to, but she didn't bother going down here, okay? So we get that right away. This is a deceptive practice. And what Linda Tacoma said was that I discovered a falsified promissory note. It was signed in 1995, and she writes back to Congressman Weiner's office, and she says that a prosecution for any felony, any other felony, must be commenced within 5 years after commission thereof. So Linda Tacoma writes to Congressman Weiner and says, yes, Miss Radin found this promissory note. She alleges that it's been falsified. It has. I wasn't a full-time student. We'll get into those details. But I can't prosecute because she signed it more than 5 years ago. And then she stopped. And Congressman Weiner didn't know any better because he's not a lawyer. And here's how she lied. It's true that a criminal prosecution for a felony should be commenced within 5 years of the commission of the felony, but there's also a 1-year fraud discovery rule in criminal prosecution. There's a 2-year fraud discovery rule in my underlying civil case, and I quote Judge Patterson to Judge Patterson, because Judge Patterson brought this up in my ruling. There's a 2-year fraud discovery rule in criminal cases for fraud and a 1-year fraud discovery rule for criminal prosecution. So let's look at that right now. So here you go. There's a criminal prosecution for fraud must be commenced within 5 years, but if you read down a little bit, it says, notwithstanding the provisions of subdivision 2, the periods of limitation, that would be the statute of limitations, for the commencement of criminal actions are extended as follows in the indicated circumstances. A prosecution for larceny, larceny means stealing, committed by a person in violation of a fiduciary duty may be commenced within 1 year after the facts constituting such an offense are discovered. So let me read that again. A prosecution for larceny, larceny means stealing, committed by a person in violation of a fiduciary duty may be commenced within 1 year after the facts constituting such an offense are discovered. So there's a 1-year fraud discovery rule for stealing in the context of a fiduciary duty. Now, does the school have a fiduciary duty to me, the student? Yeah, it does. What does the word fiduciary mean? Fiduciary means that the school is in a position of trust to the student. So, I mean, do you really have to know any law? A medical school student should be able to trust her professors. Intuitively, with a little basic common sense, of course that's true. Should a medical student be able to, let me back up for a minute. My professors in medical school took me into very dangerous situations where I could have lost my life. All kinds of dangerous situations. Should I trust my professors? Do they have a fiduciary duty to me? Of course they do. To rule otherwise has a chilling effect. But beyond that, a fiduciary duty really means, is the school transacting business for you? Of course they are. They're handling my accounts. I'm taking out student loans to pay for this. I'm applying for TAP, tuition assistance programs. I'm applying for federal Pell Grants. Of course they're transacting business for me. They're supposed to be handling my federal work-study money. Of course these people have a fiduciary duty to me, and my promotions committee's job is to monitor academic progress so they can administer federal student loans. The job of the promotions committee is not to deal with behavioral problems. That's another lie that the school told. The purpose of my false conviction, the farce of my criminal trial, was to create a false record so Martin Boxstein could run around and spread a bunch of lies and pretend he didn't do anything wrong. So, let's go back to, does the school have a fiduciary duty? Of course it does. And we're going to look at that right now. So here we go. There is an explicitly stated fiduciary duty. Oh, you know what? You probably want to see, I can go back to that because I want to get this in. There's an explicitly stated fiduciary duty, and what I'm bringing up for you to look at right now is the Code of Federal Regulations. And I'm going to enlarge this so we can all read it together. This is the Code of Federal Regulations. These are the laws, the federal laws that govern administration of federal student loans. I'm gonna make this as large as I possibly can. Okay. The school, as a fiduciary for the benefit of the guarantee agency, that's the state agency involved, in my case, the Higher Education Services Corporation, that advertises at City Hall, so I'm sure Mr. Vance can see their posters. And if Mr. Vance can't see their posters, I took photographs for him. And if Judge McLaughlin didn't see the posters at City Hall Station, I took photographs for him. Because on the Q train, the Higher Education Services Corporation, the state guarantee organization, advertises state-sponsored loans on the subway. It's hard to miss the state agency involved. But I got pictures for you, Mr. Vance. So let's go back to the statutes here. And what we've got is the school as a fiduciary for the benefit of the guarantee agency, the secretary, that would be the United States Secretary of Education, and in my case that's Margaret Spellings, and the student. The school as a fiduciary for the benefit of the guarantee agency, the secretary, and the student. Okay? This is plain English. This is not rocket science. The word fiduciary is explicitly used. The school, as a fiduciary for the benefit of the state guarantee agency that's supposed to be overseeing this to make sure that the school doesn't rip off the student, the Secretary of Education, because you're not supposed to lie to the Secretary of Education who's responsible for administering backing these federal student loans, providing Pell Grants, federal work study money, and other kinds of things, and a fiduciary for the benefit of the student. Now, let's get the overall picture here, okay? This is what Judge Patterson ruled in federal court. There's a fiduciary duty to the state guarantee agency and to the United States Secretary of Education, but not to the student. So what do we expect? That the school is going to be honest with the state guarantee agency, the school will be honest with the United States Secretary of Education, but the school will lie to the student. I mean, come on, it defies simple common sense. Even if it wasn't explicitly stated, you would have to say, you know, that makes no sense. Of course the school has to be honest with the student. That's what this whole system is set up to. We wouldn't expect that the school is going to be honest with the federal government, but will lie to the student. That's ridiculous. I mean, you don't have to be reading the law. It's simple common sense. So let's look at Judge Patterson's ruling. Remember, we're going to go low-tech for a second. In May of 2005, Judge Patterson in the federal court ruled erroneously. Let's go look at what he said. So, I'm going to put this down for a second. Let's go look at what Judge Patterson said. Okay, and let me enlarge this so we can see this. Okay. Now there are two issues here. One, Judge Patterson said that I could point to no policy, no school policy that said I, as a former student, would have the right to access and correct my records. That's nonsense. First of all, I don't need school policy. I have federal law, which trumps school policy. However, the school policy is to cite to federal law. So Judge Patterson, page 22 of my college bulletin, I appealed this to the higher courts, and the Second Circuit Court of Appeals lied. And then I went and appealed this, I did an en banc procedure to 35 federal judges. And by the way, I confirmed this with the Secret Service. Because you know, the Secret Service is concerned about the integrity of American banks too. And when the bank starts lying to the student, and when Sallie Mae starts lying to the student, and when the school lies to the student, and when the Bronx District Attorney's Office provides incomplete information to Congressman Weiner's office to deceive him, let's all look at the big picture here. Information to gatekeepers and decision makers is deliberately manipulated to deceive, to manipulate those gatekeepers and decision makers. Hence my request to Congressman Mica's office to go talk to Brigadier General Patrick Finnegan at West Point, because Brigadier General Patrick Finnegan isn't stupid. He's smart. He's a general. He sits on the academic board. He's an attorney, and he's admitted to practice law in the United States Supreme Court. And he should be appreciating this. And I will be sending you tapes of this Brigadier General Patrick Finnegan, whose job it is to protect innocent civilians like me when civilian law enforcement breaks down to this extreme degree. And I'm going to remind you, sir, these people almost murdered me. So, let's go back to Judge Patterson in the federal court. Okay, Judge Patterson says that there's no fiduciary duty, okay? And wait, I gotta... Here's the ruling that he came up with, and he says this claim for fiduciary duty fails because the Higher Education Act amendment, I'm sorry, let me go back just one second here. The Higher Education Act, that's Higher Education Act, this claim fails because the Higher Education Act and its regulations, the law that I showed you before, created a fiduciary, oh, we got a caller. Let's talk to the caller. Hello? Hello, caller. Hello, I guess we lost a call. You want to try calling us back? Okay, we had a caller, but I guess we lost him, so they can try calling us back. This claim fails because the Higher Education Act and its regulations create a fiduciary duty only between the institution and the government agencies supplying the federal funding. And Judge Patterson quoted a case called Moy. Moy and the Adelphi Institute. Okay. And here's what you need to know. Moy cited the wrong section of the Code of Federal Regulations. So there are a bunch of students at Adelphi University, Adelphi Institute, and they got screwed in the federal student loan program. They got an attorney, they sued, and the judge involved said, well, there's no fiduciary duty because the attorney made a mistake and he quoted the wrong section of the Code of Federal Regulations. I quoted to the correct section of the Code of Federal Regulations because I had studied that case and I submitted this to Judge Patterson and to the Second Circuit Court of Appeals. And they deliberately, maliciously, intentionally, with criminal intent, refused to uphold the law. Judge Patterson refuses to correct his erroneous rulings because the big game in town is that Yeshiva University wants these false rulings to stand so they can cite to them in the future and get away with hurting other innocent students. That's not the correct action that should be taken here. The corrective action that should be taken here is that my case should be remanded to the lower courts to Judge Patterson, and Judge Patterson should suck it up already, stop being an egomaniac, and correct his erroneous rulings so that never again can they be cited to hurt another innocent student like me. And by the way, I'm giving all of this to Judge Patterson's marshals, and he's embarrassed in front of the U.S. Marshals because he's wrong, he's a puppet, he's Yeshiva University's patsy. Oh, and by the way, I will be taking this to the House Judiciary Committee because a judge who lies to this degree does not deserve to sit on the bench because he's not a judge, he's a co-conspirator in very serious crimes. So let's go back to Judge Patterson's ruling. And this part of his ruling here, this is page 27. Moy was wrong. Moy cited to the wrong section of the CFR. And in this footnote, Judge Patterson claims that the defendants that I cited in my case do not handle money or property for the benefit of the plaintiff. Of course, the people I cited in my case handle money and property for me. Oh, look, we have a caller. Let's try to get the caller. Hello. Hello, caller. You're on Crooked Doctors. Do you have a question for us? Comment? Hello. Okay. Hello, caller. Okay. Well, you can try calling back, or you can email us. We have an email. You can email us at crookeddoctors@yahoo.com, and I'll respond to your emails. You know I'm here every Friday, so you can try again next week. Let's go back to looking at Judge Patterson's erroneous ruling, and what he says is that the defendants do not handle money or property for the benefit of the plaintiff. The plaintiff is me. Of course they handle money for me. It's ridiculous. The job of my promotions committee by federal law is to monitor academic progress, because you don't take out loans to go to school and then don't do anything. And by the way, these are scams that were run in the federal student loan program. That's why the system is set up this way. There were students who took out loans, were promised classes. Those classes were never delivered. The job of the promotions committee is to monitor academic progress so they know the money is being spent appropriately. You don't take out money for federally backed student loans then just don't do anything. That's ridiculous. Of course my school is handling money for me. They're handling my accounts. They're getting tuition assistance TAP grants from the state. They're getting federal Pell grants. They're supposed to be administering federal student loan money. I mean federal work study money, which I asked for and didn't get because the school discriminated against me and then lied about it. I should have been able to, like other students, apply for grants to fund my research project. Recall, I was recruited to this school because the school promised me that they would support student research 100%. They acknowledged that my work was meritorious. I was on track to be a principal author on 3 to 5 published papers, but they didn't allow me to make grants to support my work. And after my illegal expulsion, I demonstrated that I could get grants because I got a grant for over $20,000, a federal grant after my illegal expulsion. I see we've got like less than 2 minutes left. So what I'm going to do is just go through some of the highlights again. What you want to do is you want to go to the blog site, and if I can pull up the blog site really quickly, some of that information. We're going to go out in about, the show is slated to end in about a minute and a half. So if you want to email me at crookeddoctors@yahoo.com, if you want to go to our blog site, I'm publishing the documentary evidence, and if you give me about a day, I'm going to put up Detective Cologne's testimony. It's a few pages, it's a few quotes. Detective Cologne admitted on the witness stand that he lied. He admitted that yes, Ms. Radin's complaints came first. They came in 2005, that had no retaliatory motive, and that the school lied. And if you give me just, we're out in about 30 seconds, so if you go to the blog site, you'll see me summarizing up this information. So, in effect, this is oral argument, Mr. Vance, and I'm providing the timelines, the documentary evidence, and the narrative for you. So if you go to crookedDoctors.blogspot.com, each of these shows will be keyed in. Thanks so much, and I look forward to your comments on email. And you can email me at crookeddoctors@yahoo.com.